This is Paul Turner, the Immigration Barrister at Imperial Chambers. Thank you for tuning into my channel. Please subscribe and hit the notification button for immigration news, and if you have an immigration problem, contact me. Today I'm going to be talking about an immigration route which I've not really covered in my previous videos, and that is what is called the Stateless Persons nationality route. This is a potentially underused route to gaining permission to legally remain in the United Kingdom, and a number of my clients have benefited from this route in the past. It is a little unusual, so I'm going to go into it in a bit more detail. It's a route that's been used by Indian nationals who have had children in the United Kingdom, and the children have got to the age of 5, but they've not registered them or their births with the Indian High Commission. And following a case in the High Court, a case called MK, that meant that they could be treated as stateless and then therefore given British passports, which then obviously would lead to the parents being granted status. It might be helpful first to understand what a stateless person is in immigration law. It's a person without nationality who is in the United Kingdom and is refused to be recognised by any other country in the world, and as a result has no right to reside anywhere. Those applying for leave as a stateless person in the United Kingdom must of course demonstrate that they have taken reasonable steps to gain admission to the country where they used to live, or any other country in that fact, but have not been able to gain the right of admission. This is obviously to stop people saying, well, I can't live anywhere. They must also have tried but not been successful in obtaining or re-establishing their previous nationality with the appropriate authorities of the country or countries in which they've lived. This is also evidence-based, and why a lawyer is helpful. The UK provides the right to apply for leave as a stateless person in accordance with the 1954 United Nations Convention on the Status of Stateless People. Some individuals, however, may be refused statelessness or refused leave as a stateless person, and this covers people that have protection from an agency of the United Nations, which affects a lot of the West Bank Palestinians, are recognised by the competent authorities where they used to reside as having the rights and obligations with the nationality of that country. So they might not have the nationality of that country, but they're allowed to stay there. This is also relevant. They can't have committed a crime against peace, a war crime, or a crime against humanity. I mean, it goes without saying really, but there it is. Also, they can't have committed a serious non-political crime outside the UK before coming to the United Kingdom. So they can't, say, be a murderer that's come to the United Kingdom and is stateless. And they can't also, this is a little bit loose, they can't have committed acts which are against the purposes and principles of the United Nations, and of course they cannot pose a danger to the security or public order of the United Kingdom. We've all seen what's happened in the newspapers and news in respect of the deprivation of somebody's citizenship in that regard. And then they also they can't meet the general grounds for refusal: criminality, making false representations, and previous breaches of immigration rules. A major benefit of a statelessness application is that it's absolutely free of charge, so you don't have to pay the Home Office a huge sum of money. Well, then the next question is, what documents are required for a stateless person application? Well, it might be helpful if I go through some of the documents and then you'll have an idea of what you need, and of course I'm here to help if you want the help. The documents you may need to prove or provide, but they're not limited to the following: are passports of your old country, an official letter confirming your immigration status, birth certificates, marriage certificates, any additional identity, immigration and travel documents that you have, evidence of where you lived before you come to the United Kingdom, such as military service records, school certificates, tenancy agreements, medical records, or, if necessary, sworn statements from your neighbours. And then, crucially, evidence that you've applied for citizenship or requests for proof of nationality in other countries. This is key to showing that you are genuinely statelessness. For ease, you will be given, if you decide to go down this route, a full list of exactly what documents are required, but I've just outlined the main documents. Now I'm going to turn to stateless children born in the United Kingdom. Now, what is a stateless child? Well, a child born in the United Kingdom might be a stateless child if they have attempted to register their birth with the relevant authorities in the country where they were living and this was refused. This is where the real issue comes in, which is that a number of children born to Indian parents in the United Kingdom who didn't register their births at the Indian High Commission have, following the High Court case of MK, used this as a route or loophole, one as the Home Office might see it, as a way of getting British citizenship lawfully for their child. And then obviously the parents then make an application based upon having a British child. I've done a number of these and they've all been successful. It should be noted that those considering a stateless application, that new rules for registration as a British citizen will start to apply. The Stateless Child Born in the UK New Rules for 2022 explains that a stateless child born in the UK or British territory after the 1st of January 1983 can apply for British citizenship if they were statelessness when they were born, and they always have been. They have been in the UK for a full 5 years before applying, so that still includes the Indians. They haven't been absent from the UK for more than 450 days in their 5-year period. And of course they're under the age of 22 when they apply, so that's even older than the normal 18. And they were not able to gain nationality if they were aged between 15 and 17. So the rules aren't that strict. Now what happens if you make the application? If you're granted leave as a stateless person, you can stay up to 5 years. If you have dependent family members outside the UK, then they can apply to join you in the United Kingdom, so that's also positive. Once you've accrued your 5 years living in the United Kingdom, you can apply to stay on the same basis, or alternatively you can apply for indefinite leave to remain if you wish to do so. If you then apply for indefinite leave to remain, a year later or so you can apply for a British passport, and then you obviously have some citizenship. If your application as a stateless person is refused, you may be able to apply for an admin review within 14 days or appeal the decision. Your rights to appeal or request an admin review will be explained in the decision letter. An admin review costs about £80. However, this is quite a slow process and can take up to 6 months to complete. Where this has potentially the best benefit is stateless children, because that's where we've had most success, especially with Indians that haven't registered a child's birth at the Indian High Commission. The child will come will come and see me with the parents. There'll be evidence that they've lived in the United Kingdom for 5 years. They've not registered the birth with the Indian High Commission. Following the case of MK, then the child is recognised as stateless, and then that enables the parents then to get on with making an application based upon having somebody legally in the United Kingdom. So the stateless route is a underused route. It can be very complicated because the Home Office won't just accept your word that you're statelessness. We have to go through some steps to showing it. It's easier with children, it's a lot harder with adults, but it's certainly not impossible, and it is a unique route that is, in my view, underused, especially where there are certain countries where they are not so receptive to receiving their own nationals back, or are very difficult, or where it's impossible to get documentation from. I hope you've enjoyed watching this video. If you have, please subscribe to my channel, and if you have an immigration problem, please get in touch with me and I'll do my best to help you. Thank you again for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.